This is Elizabeth Townsend. It's August 2nd. This is a interview with Professor Mauet for Dean Massara's project Preparing for Lives in the Law. Before we begin, we've asked a couple quick questions, sort of your personal, if you don't mind. You don't. The other thing about the interview is it's going to be all chopped up, and so if you don't want to answer a question, you don't like it, we can just change it.
I'll make
around.
a face, and that will be the
Right,
end of that part.
exactly.
Yes.
But so the first question is, how did you decide to go to law school, and was it what you expected when you got there? And then we'll get on to the stuff we talked about.
I probably went to law school as a last-minute thought or a last alternative. I was a history and government major, and I thought I was going to go on, get an advanced degree in history or political science. And my history professor, who was my advisor, who was a crusty old Yankee, said, "Why do you want to do that?" And he said, "There aren't any jobs out there if you get a PhD in history or political science. Why are you going there?" And he was the one who first suggested to me, this was in the beginning of my senior year, that maybe I should take the LSATs and consider going to law school as a place where you can do something that's interesting and find jobs at the end of the road. So that's how that got started. Otherwise, there's nobody in my immediate family that was a lawyer or had been, so I knew nothing about lawyering. So it was my advisor in college that really suggested it, and I applied and ended up going.
And was it what you expected, or did you have no expectation?
I would say where I went to law school, I was disappointed compared to my undergraduate years. Maybe that was just a comparison of the two schools or the two types of students there. Maybe it was grad school versus undergrad. I certainly didn't think law school was nearly as much fun as the academic side of undergraduate living. And at the time, I didn't think it was nearly as intellectually interesting. Maybe that says something more about me than law school, but at the time, I was a little disappointed.
And because it was, talk a little bit more about what disappointed you.
I guess I was disappointed in law school, certainly the first year with the faculty from a teaching point of view. They weren't nearly as interesting as the professors I've been used to as an undergrad, so that was disappointing. I thought the students that I went to school with were all these highly motivated students who desperately wanted to be lawyers and had no interests other than getting through law school, doing well, and working as lawyers afterwards. So the breadth of their interest was pretty narrow. I found that disappointing. It was difficult to engage people in law school, that is other students, on anything other than law. They were totally immersed in it. I wasn't. So as a result, most of my social friends in law school had nothing to do with law students. It was a world totally removed from that, and that was my choice. So I'd say the first year was a little disappointing. It also took me a little while to get into the rhythm of what exams are all about, what expectations were. And after about a semester of it, I did fine academically, but I never found law school nearly as interesting as I had in my undergraduate years.
And what about as a professor? You come back, we'll talk lots about lots of things, but compared to your
Yeah, well, it's odd. When I graduated from law school in 1970, and the last thing I ever thought I would do would be to teach law at the law school level. When I graduated, I turned my back, and I don't think I went in the law school building for probably 3 or 4 years after I graduated, even though it was only a mile from where I was practicing. It was sort of out of sight, out of mind. I'm glad that's over, and I'm never looking over my shoulder again. And I think what happened was I started getting interested in the law after I started practicing it. And I found the practice of law was interesting. And dealing with the people and solving problems, that was interesting. That was fun. That was challenging. Doing trial work is challenging and very interesting. Much more so than the academic side of law ever was when I was a student. So it took my getting into practice to get interested in the law. And I found once I was practicing it, I found it very interesting, especially the interplay between the people and the legal problems. I guess I discovered law after going to law school, in a sense. Maybe I'm not the only one. And I'm not saying that I hated law school. I just didn't find law school the interesting kind of academic, intellectual environment that my undergraduate years have been. And that's usually the opposite of what most law students will tell you. That's why for me it was a disappointment, and then once I started practicing, things started coming back.
And then what made you decide to come back as a professor?
Well, I had started to teach part-time as an adjunct at 2 local law schools in Chicago. And I taught criminal law one time, and then a little later started teaching trial advocacy. And I found that the teaching of those courses, again, teaching them at a functional level rather than a high abstract intellectual level, was fun. And now teaching seemed like fun. And I started doing more and more teaching on the side, and one thing led to another. And I also started writing a little bit about practice issues for just bar journals, things of this sort, doing seminars from time to time. And then I started writing my first book, the Trial Techniques book, in my spare time when I was still in practice. So I was unwittingly doing, while I was practicing, the things that most law faculty do when they're on a law faculty, that is teaching and writing. So that finally when the opportunity came to teach full time, I had a good inkling of what it was all about because I'd already been doing it for a while.
Usually we ask some of these questions towards the end, but since we're on this topic right now, I'll ask you just a few more. Do you think that, sort of talking about what you had just said of sort of academic space versus practical, do you think that your evidence, I haven't taken your evidence class yet, but what is your evidence, I mean, your introduction to your book says your book is different because it's much more in the grounded in the real world, and sort of how this is going to be used. My question, I mean, it's an obvious question of sort of what are these classes supposed to be doing for us in law school?
Well, I don't think any one law teacher can be all things to all people, first of all. That's common sense. Mm-hmm. I think the first thing you decide when you teach is the type of teaching you feel comfortable with, that you think you can do something that is useful to students. With me, I always thought my strength was dealing with practical, real-world issues. I guess that's because I spent all those years in practice. That comes naturally. I'm much less comfortable dealing with evidence issues as abstract, theoretical issues that academicians can debate endlessly. So my own approach to teaching evidence or criminal procedure or trial advocacy, the various courses I've taught, pretrial litigation, have always been to try to have a reasonable mix of understanding the concepts behind the rules, but always applying them to real life problems. To me, I could never learn anything very well if it remained just theory. You have to apply the theory to real world problems that students can imagine actually happening out there in the real world. And you learn the theory, you learn the substantive law, in my view, by applying it to real life problems, much better than if you just keep it at an intellectual level. So that's been my approach. It's not to say it's the only one. I think law schools obviously are benefited if they have a good blend of both approaches. But I don't think law schools should have theoretical, conceptual only kind of teaching, nor should they just have functional skills teaching.
And then this is an obvious question by what you said, but since it's one of the issues we were asking people is this notion of PhD, JD versus people who have practical experience. And I would imagine your answer is you should hire all of the different types, or do you?
Yeah, to me, variety counts. I'm not in favor of hiring just JD PhDs I'm not in favor of hiring all interdisciplinary people. I think that narrows the approach, and that's not good for students. Conversely, though, I don't think we should hire only people who have spent 10 or 20 years in practice and will teach solely at the functional level. That's not desirable either. But I think a healthy mix is good for the teaching of law in general, and is good for the students in law school when they're there to get exposure to both ways of looking at things. Both obviously will have some benefit when you get out. Having said that, though, I think it's clear that at the national level, more and more of the hiring is in the direction of the joint degree, the PhD types. Interdisciplinary is quite in vogue. In fact, you see law schools now that are hiring, law schools, mind you, that are hiring as faculty people who have JDs, people who have PhDs and no JD. Hardly unheard of. I have problems with that. I would not be in favor of that occurring here.
Yeah,
We have not done that yet, but it is clear that the trend is toward interdisciplinary, toward lawyers that have PhDs. And in fact, sometimes they hire PhDs without the lawyer side of the background. That's where I would certainly draw the line.
Yeah, it seems like that law school is such a culture. It's such a way of thinking. I mean, it's cliche to say that, but to not have that, it's bringing you into a particular type of culture. It seems very...
I think it helps when you're teaching a law school to know what it was like to be in law school yourself. Mm-hmm. I think it helps when you're teaching in law school to have spent some time in practice, so you have a clue what the real life issues are that lawyers have to deal with in the particular subject matters that you're teaching. That's just making you more knowledgeable and making what you pass on in the classroom more useful. I keep telling myself almost all the law schools in the United States predominantly graduate people who will practice law. In fact, I think that's true of every law school in the country. The majority of them practice law. Even at Harvard, Yale, Chicago, places like that, a majority of the graduates actually practice law. Once you get out of that top echelon and you talk about, well, there must be 50 or 60 law schools, much like the U of A, well-supported state law schools who've been around for a while, the great majority of their students go into practice. I'm sure it's over 90%. And if that is the reality, that is where your graduates go. I've always had the attitude that then you have some obligation to prepare them for that. And that involves more than just spending 3 years discussing legal issues at the conceptual, theoretical level. I don't think that's enough.
And let me ask you one more question. On the other flip side of it, is there any reason that you see the theoretical side? Is it necessary? I mean, there are some people who just want practical. They don't want any of the theoretical stuff. Is there any reason they should have it?
I hear that from students enough. Oh, I think anything that's a mind stretcher that gets you to think a different way or gets you to think about new things is an inherently good thing when you're going into a profession where brain power is a useful thing to have. And a certain amount of pure intellectual endeavor is a good thing. I just don't think that should predominate. And I don't think it does here. I think most of the faculty here understand that and have a reasonable mix between the academic, the purely theoretical, and the functional. To my way of thinking, that's a good thing.
I don't want to run out of time, so is there anything else you want to talk about on this topic, or do you want to move on?
No, why don't we move on to
our main topics.
Go ahead.
Good.
Fire away, I'll see what I can do.
All right, so let's start with the first one that you said about assume that you want to be a trial lawyer, and how do you get there, and what do you do once you graduate from here?
Well, the easy answer would be, if you want to be a surgeon, sooner or later you're going to have to perform surgery. By the same token, if you want to be a trial lawyer, sooner or later you'll have to try cases to become one. So the question really is, where can I go after graduation to try cases? My own view is that I don't think someone is an experienced trial lawyer unless they've tried, maybe 25 jury trials and a bunch of bench trials. In my experience, you need that number of trials before you reach a certain level of accomplishment, smoothness, comfort, confidence. That's necessary for doing trial work well. So there's no substitute for experience. And I say that even though I teach trial advocacy in a law school, that is a great start. I wish I'd had trial advocacy classes in the 60s when I was in law school. We didn't. So when I started trying cases, it was from a position of almost total ignorance. That's not a good thing. Obviously, trial advocacy and skills courses can get you started, and in my view, they are a very good substitute for the first several jury trials you might otherwise try on your own. But they can't give you the kind of breadth and depth of experience that actually trying cases can. So the question gets back to, when you get out of law school, how do you get to try cases? To me, there are certain rules that have always been true in the years I've been a lawyer and are still true today. First, practically all of the jury trial work that's done in volume is done on the criminal side. So if you want to try jury trials when you get out of law school or soon after you get out of law school, the reality is that you almost certainly have to do criminal work for a few years. I'll give you an example. When I was a county attorney in Chicago, I can remember one year when I was a county attorney, I tried 22 jury trials and probably as many bench trials in 1 year. You can't get that kind of saturation experience on the civil side. It just doesn't exist. And probably the larger prosecution and public defenders' offices, the larger ones being the larger cities, have the kind of volume where you can be on trial a lot if you want to be. I would say county attorneys and public defenders at the county level try a lot more cases than U.S. attorneys and federal public defenders. Give you an example. When I left the county attorney's office, I was a U.S. attorney for a while. I would try perhaps 4 jury trials and 4 bench trials a year. That was 20% of what I would do as a county attorney, and that's typical. But even those numbers are high compared to the civil side. It's pretty rare these days to find a trial lawyer doing civil litigation, mainly personal injury, who tries more than 3 or 4 trials a year. That would be considered a highly active trial practice. And the reality is, for students coming out of law school who want to be trial lawyers, the reality is they are least likely to try cases if they join civil litigation firms. They join big firms in big cities. The reality is, if you go to New York, Chicago, Los Angeles, any major metropolitan area, and you join a large firm, the odds are almost 100% that you will not be trying a case yourself for a number of years. That's why I've been telling students for years they have to decide what they want to do. Do they want to join a big firm for the obvious advantages that a big firm have? That's fine. But if they really want to be trial lawyers, they need to try cases to verdict in front of juries. And chances are that's going to be a jury trial. So my standard advice to them is join the public defender, join the county attorney. I couldn't care less which side it is. Get your trial experience there. When you've done 50 jury trials, whatever it is, then you know what you're doing, and then you can afford to leave, go into the civil practice, and have that jury trial experience behind you. That's where it's a big, big advantage.
If you're going to do that then, do you take criminal law classes, or do you take things that will help you with civil litigation, or how do you prepare for something like that?
I'm a big believer in having a broad education. I think trial lawyers are one of the last generalists in the practice of law. And I encourage everyone every year, especially when we have those meetings with first years deciding what to do in the next 2 years of law school, when I talk about being a trial lawyer, I encourage them to take the core curriculum courses, not just criminal law and criminal procedure. Obviously, you would want to take those, or you have to, and you would need those obviously to join a county attorney or public defender's office. But I think it's a big mistake not to take the core curriculum. Take UCC, take trusts and estates, take remedies, take advanced torts, the kinds of courses that broadly describe the causes of action that you'll be litigating somewhere in your life, even if it isn't the first few years when you'll probably be doing criminal work. I don't think it's a good idea for students to take the practice-oriented courses, my kinds of courses, and ignore the broad substantive courses that they really need for a solid underpinning. I think that's a constant danger, and I preach about that every year.
Okay, what if a student wants to do appellate work, but that's their goal? They love that idea.
I think the reality there is that now things change. If it's not trial work you want, but you want appellate work, then I think working for a civil litigation firm is as likely and maybe even more likely a place. The reality is that when you work for a big firm, you're going to be doing a lot of memo writing, brief writing. Anyway, that ties in so logically to appellate work. In addition, large firms that do litigation work will always have appellate lawyers. And if you're interested in that, you can do meaningful appellate work on the civil side and in a large firm context. The other extreme is if you are in large county attorney or public defender's offices that have divisions, and many of them, they have separate appellate divisions. For instance, when I was a county attorney, they started me off in the appellate division, and I spent 8 or 9 months doing nothing but appeals. During those 8 or 9 months, I argued about 25 times in the appellate court and 5 or 6 times before the Illinois Supreme Court. So I got a lot of appellate experience in brief writing and oral argumentation at both the intermediate and the Supreme Court level very, very quickly. Lots of large metropolitan county attorneys and public defenders' offices are set up that way, and sometimes they start their new deputies in the appellate division. The idea being that's the place to learn the substantive and procedural criminal law. After they learn it, then they go into the trial division. So as far as appellate law is concerned, now you've got two good vehicles. The criminal side in the larger metropolitan areas, and the civil side, again, larger firms, larger metropolitan areas, will give you more chances to do meaningful appellate work. But this time it's not all criminal.
What about students who don't ever want to do litigation? What do you say to them?
Well, I would tell them, talk to other faculty members that are transactional people, because I think the statistics I see show that somewhere around 25 to 30%, somewhere in that range, of practicing lawyers do litigation work. May not all be trial work, they may be commercial litigators, they may be bankruptcy litigators, or there's all kinds of litigation, but somewhere in that range, which means a good 2/3 to 3/4 of lawyers are doing transactional work. That's a different kind of beast. That's not where I had my experience, so I would tell them, talk to someone other than me.
Do you, let me ask one more question on that. Do you think that even if you don't want to do any litigation, that you should be exposed to it at?
Yeah, okay, that's a
That's the
very
question.
good point. Sometimes when students ask me, I don't want to be a litigator. I don't want to be a trial lawyer. I want to be a transactional lawyer. Why should I take any litigation-related courses? And I think the answer is twofold. It's still something you should consider for two reasons. One is at a purely personal development level. I think in law school, a lot of students are still a little shy about being in an adversarial context, are still shy and a little reserved and afraid to stand up on their feet in front of crowds. Just your ability to speak and argue and persuade before anybody, not just a jury, is an important skill. And to the extent that you have some experience trying cases, I think that's a big help in making you a better communicator, especially an oral communicator before any group. That's obviously a useful asset, even if you're doing transactional work. The other thing I point out regularly is that if you have some experience in deals that have gone south, that have resulted in litigation, you become a lot more sensitive when you're doing transactional work to take the kinds of steps necessary to minimize the likelihood that litigation will flow, and if it does, that you will have adverse results in the litigation. Sometimes I make the analogy that if you learn appellate work first, it makes you much more sensitive as a trial lawyer to avoid the foolish things lawyers do that create problems on appeal. By the same token, even if you're a transactional person, having seen some commercial litigation on deals that have gone bad and have resulted in litigation gives you a real insight onto what could have been done earlier to avoid the litigation we're now in. And that is something that people sometimes don't see, but I think is very true. Doing litigation shows you what to avoid when you're doing transactional work. And I think it's a good experience for that reason alone.
What about the notion that you have to have a certain personality to be in litigation?
I don't buy that. I think that's one of those kind of law school derived from TV notions. That you can't be a trial lawyer unless you look pretty and talk nice and all the kind of superficial things that TV emphasizes. I've known hundreds of trial lawyers in my life, and they come in every shape, form, men, women, old, young, outgoing, quieter. The personalities of trial lawyers are as diverse as people in the human population are. So I don't think anybody should ever look in the mirror, look at themselves and say, I can't be a trial lawyer. I don't buy that. The other thing I would say is that people think that jurors have such preconceptions over what a trial lawyer is like that if you don't fit that preconception, you shouldn't be in the field. I don't buy that. I've tried cases against the quirkiest, most unusual people, and 5 or 10 minutes after trial gets started, and the jurors have warmed up to the oddities of the lawyers that are trying the particular case in front of them. After that, it just doesn't come into play anymore. There is no such thing as a trial lawyer personality, and I don't think jurors expect it.
All right, here's another question, and we'll move on to the next topic. Okay, so you take your class, and you're not very good at it. Like you struggle, and it's not your cup of tea.
This is what, trial advocacy?
Yes.
Okay.
But you still really want to do it. Is it something that you can learn, or is it something you have to be good at from the beginning? You talked about needing experience, so.
I would say that, say I have a section of 16 students in a basic trial advocacy class. My experience has been that 2 or 3 of them really ought to be in this area. They have real advantages. They come across as nice, reasonable people that you're glad to be in the presence of. They have good communication skills. They're fairly quick on their feet. They relate well to a wide variety of people. Obviously, those are things that you want to have. And some people you see immediately have them. I would say at the other end, there are probably a couple students in each section of 16 who, for one reason or another, this shouldn't be their line of work. I'd say for the great majority of them, though, that if you want to be a trial lawyer, you can. Because almost everybody that went into trial work was pretty bad when they started. So the fact that if you take an introductory trial advocacy course, you're not great, you're not the obvious class star, has nothing to do with whether you will be a good trial lawyer down the road. In fact, I would go one step further. When I started doing trial work, I saw some lawyers that I thought were pretty good. It turned out pretty good at the superficial level. They look good, they talk good, that kind of thing. 10 years later, I looked at them and I thought, these people are really second stringers. They were competent quickly and then never did the work to become really, really good. My experience has been that very often the people who become the great trial lawyers were not the ones who were great on day one, but had a realistic capacity to self-analyze and self-criticize and wanted to get better. And those people may have started off from nowhere, but every year as they gain more experience, they get better and they make themselves better and they end up being very good trial lawyers. I don't buy this notion that to be a great trial lawyer, it must be obvious immediately you're great and you'll continue on at that high plane. I think most trial lawyers are developed and they start from rather humble beginnings. You ask any trial lawyer that, and I think most will tell you that. When they started, they weren't very good, but they worked real hard to get where they are today, and it didn't just drop in their lap. That's why I think most people, if they want to be trial lawyers, they can be.
Okay, a couple questions. What about that notion that you have to be a bulldog? You just said people who are nice, that there's a sort of...
Yep. I think that's another common perception about trial lawyers that the public has and probably law students have. That is the most aggressive attack dog is the most successful trial lawyer. My experience has been that that is not only not true, but that the converse is true. That jurors don't like naked aggression in the courtroom. They don't like overbearing lawyers. They don't like lawyers who pick on witnesses unfairly. In short, over-aggressive lawyers usually pay the price. My experience has been that the jurors respond most favorably to lawyers who seem like reasonable, decent people. They're not shrinking violets, to be sure, but they're not overly aggressive attack dogs. That doesn't sell in the courtroom.
And what did you do in your experiences when you came up against an attack dog or someone who was a bully?
I learned quickly you don't want to fight fire with fire because then you lower yourself to that person's approach. And if the jury doesn't like it when the other lawyer does it, they won't like it when you do it. My approach generally was, if I thought a lawyer was obnoxious, unfair, sneaky, I wanted that trial to last as long as possible so that the jury could get the full flavor of it. So I'd hope to have a trial run a little longer. And my experience was that usually jurors would get sick and tired of those kinds of tactics, see them what they were, and within a day or two figure it out. The only time I ever worried about the attack dogs is if it was a short one-day trial, and my concern was that the jury wouldn't see through it because they wouldn't have enough time to see through it.
And then the other thing is, my dad did some trial work early on, but when I was a little girl, he would always tell me about how he was in San Francisco and go see the great trial lawyers. And do you, is that myth? I mean, or sort of like, is that something people should be doing, or is it,
Yeah.
you know what I mean? And how do you find out who the great trial lawyers are?
Oh, you can ask around. You may not know who all the good trial lawyers are, but in the specialty areas, criminal law, you know who the good prosecutors and who the good defense lawyers are. Just ask. Ask judges, ask lawyers. Everybody has their consensus list of who. Same way with the personal injury field. People know who the good plaintiffs' attorneys and the good defense attorneys are. And it's the same in commercial litigation, even though that involves less jury trial work. you can find out who the good lawyers are. And your question also was, are they worth watching? Oh, I think so. Not watch so you can steal their stuff. I mean, every lawyer shamelessly steals from other lawyers, but they don't steal it and use it identically the way they saw or heard it, but they modify it themselves. For instance, when I was in practice, I kept a ring binder. And every time I heard a good closing argument, some routine, I'd make a note of it. Here's a great analogy in an identification case. Here's a great argument in a self-defense case. And I put it in my ring binder under closing argument. If I saw a great cross-examination of a doctor or a ballistics expert, I put it in my expert section. I think all good lawyers do that. They watch the good lawyers and they use what they see there, and then they modify it for their own purposes. Bottom line is, oh yeah, it helps a lot. The other thing is it really broadens your thinking about what you can do. Well, I found that when you start off, you do things that you're comfortable with, that come naturally to you during a trial. And if you never watch other lawyers do things, it never even occurs to you that you can do certain things in a trial totally differently and have them have impact. And the way you learn that is to read, hear from other lawyers, but also watch them in court. I think that if the word is you've got to watch other trial lawyers, I think it's a good word to take heed from.
You make it sound like that trial lawyers are like artists or actors, or that there's a
I would
special
say
about it. And
I'd say at the superficial presentational skills level, yeah, it's very much like actors watching other actors do a scene that they themselves have done, and they see another actor doing that scene in a way that gives a totally different interpretation to the scene. And suddenly, as an actor, your eyes are open to, wow, there's an entirely different way I can do this scene. That's not to suggest that trial lawyering is acting, but to the extent you see other lawyers do the trial skills you have to have during the course of a trial, seeing another lawyer do it in a way that's totally unexpected, that you would have never thought of, broadens the possibilities. It broadens your range, and I think that's an important part of your development as a trial lawyer.
okay, what about the idea that I want to be a trial lawyer, but I also want to have a family, whether you're a girl or a boy, but that I don't want, and that you hear that you are never going to see your family, and you have to give up all of that.
I don't think being a trial lawyer and family issues is so much a gender thing. I think it's the kind of practice you have. When I started out as a county attorney, my partner was a woman named Patty Bobb, who was the first woman to be in the felony trial division of the Cook County State's Attorney's Office for a long time. Now, of course, it's common, but back then when women were just starting to practice in large numbers in the early 70s, she was the first one to have made it to the felony trial division, and she was my partner for a while. It didn't cause her any more problems than it caused me. But there are some exceptions. Another county attorney friend of mine, Lorna Probst, 2 years ago was the lead defense counsel in a class action breast implant case involving Dow Chemical in New Orleans. And she was down there almost a whole year trying that case away from her husband and family. So it can happen. But I wouldn't characterize this as, can you be a trial lawyer and be a woman and have a family, or be a father and be a trial lawyer and have meaningful contact with your family. I think it's much more the kinds of cases you do and whether you stay in your own backyard. There's certainly lots of county attorneys and public defenders that have active trial counters, both men and women, who do trial work, and there's no problem. I would say it's somewhat more difficult at the big firm commercial level, because in that kind of practice, you tend to travel more. You're doing a lot of out-of-town depositions, you're meeting clients out of state. being on the road is a more serious fact of life when you're doing the large firm commercial litigation kind of work. And there, being a litigator is going to be more disruptive in your family life, whether you're a man or a woman. So I would say, look not to the gender aspects of doing trial work. It's look to see whether you're doing trial work that takes you out of town, and whether the trial work that you do involves long, extensive trials that are somewhat disruptive. But you've got to remember, most trials probably take 3 or 4 days. That's your typical personal injury case, typical criminal case. The rare cases are the ones you sometimes read about that go on for weeks and weeks or a few months. Antitrust cases, huge commercial cases. But those are relative rarities. I think you can have a life and be a trial lawyer.
All right, and how about we'll go to the next topic before we run out of time. The expectations imposed on young lawyers now as opposed to 30 years
Yep.
ago.
No question there were changes. Give you an example. The first 2 years I was in practice, I worked for back then, what was considered a medium-sized litigation firm, civil litigation firm. The first year, the firm didn't even, that was 1970, did not expect me to regularly keep hours. They would tell me if there was a client that they wanted me to keep my time on. Otherwise, I was just working for partners and doing all the stuff that a new associate did. Today, that would be unheard of. I mean, today, you better be a billing machine early and often. But 30 years ago, the pressures were not there. The hourly expectations tended to be in the 1,600, 1,700 hours a year. In fact, when I left the practice at the end of 1980, the firm I was with then, their hourly expectations were 1,750. I don't know any firm that will let associates survive with that kind of billing rate. So in 30 years, there's been a wholesale change in, I would say, 2 areas. One is the billing expectations. I don't know of any large firm in a major metropolitan area that doesn't expect at least 2,000 hours of their associates. And that's just their stated minimum. The message is implicit but quite clear that if you really want to be on track to partner, you better be better than that. How much better? Well, I hear from lawyers that they expect their associates to bill 2,400 hours a year in New York, for instance, if they want to make it. Nobody will go on record as saying that, but everybody knows what the expectations are. That's a quantum leap more than anyone ever expected associates to bill 30 years ago when I started. That's the first big change. The other big change is that when I started, all they wanted you to do was do good legal work. And if you did good legal work, why you would make partner in 7 years? Because the firm had long-term institutional clients. So you didn't need to get clients. The firm had clients. The reason they hired you as an associate was to service the clients they already had. Fast forward to today's climate where there's no such thing as client loyalty. Clients are shopping around for lawyers, and it's changed the expectations of the associates. I think every associate in a big firm now has sessions in their first year in which they talk about client development. Young associates have to come up with a client development plan. Well, if you're trying to build 2,000 plus hours a year and engage in client development, whatever that means to a first-year lawyer, that's not an easy task. But those are the two pressures that have been put on lawyers. It's very clear that if you're just a good lawyer without a client base, you will not be a partner in any good-sized firm. That's a prerequisite. And you better bill like crazy. I think that's the reason so many lawyers, after they work for large firms for a few years, shift gears and start migrating from big cities to smaller cities, from bigger firms to smaller firms, and from the civil side into the public sector side. Very common migration. Obviously that kind of rat race, if you want to call it that, in the big firms doesn't suit everyone. It works for some, but it doesn't work for a lot. And that's why you see, I think, the turnover in the big firms so large. You see some of these large firms that have several hundred, maybe 1,000 lawyers. They will have 15 or 20% of their lawyers not have been there a year. Every year it's a new influx, and in the second, third, fourth, fifth, sixth years, people are leaving at about the same rate they're importing a whole new class. There's an awful lot of mobility, and the mobility ought to tell you something.
That seems like it would just change the whole nature of what's
Oh, it
there.
does. I actually liked my first 2 years when I was doing commercial litigation for a middle-sized firm under the old rules. Just learn to be a good lawyer, work hard, but work reasonable hours, and work at becoming a good lawyer. No client development, none of that stuff. And I thought practicing law at the civil side, civil litigation, was fun. You talk to today, and not a whole lot of people say working for the big firms with those kinds of time demands and the other pressures is fun. It's not. I think that accounts for the high turnover rate.
What about the notion of being on track? How much should you be worried about being on track? If people are going to be leaving that whole notion of partners drives this whole system. So how much should you be buying into that?
Well, I would say that's used to be totally right, but I think today is half right. That is, becoming partner was the holy grail, otherwise why would you join a firm? I would say that was certainly true, and that was the expectation when I started practicing. When you joined a firm, you expected to make partner after a few years. Today you see a lot of associates take a contrary view. They may say privately, that is, I'll go to the firm, I'll work there for 2 or 3 years, I'll make the big bucks, work like a slave, but I'll be able to pay off a good chunk of my student loans. They use it for loan reduction, but once they get their loans under control, they can now afford to leave. And they had no intentions when they first joined the firm of sticking around to make partner. They knew it was a rat race. They knew that the hours are prodigious. It's kind of like being a resident in med school and a medical facility. 78-hour work weeks is not fun for anyone. And just like residents may do it for 3 or 4 years, and after that they can get board certified in their specialty, lawyers joining large firms are willing to do what residents do, work 70, 80 hours a year for 3 or 4 years to accomplish their immediate objectives, learn something, have useful skills, but also, importantly, pay off or reduce their student indebtedness. Then they have financial freedom. So this idea of joining a firm to become a partner is true for some, but it's not true for a lot, and they know it going in.
Does that change how they interact at the firm, just on a personal, not even if the firm knows it, but just in their sort of choices, or how much extra time they put in or whatever?
My guess is that if they know they're not going to be there for the long haul, my guess is that they're going to probably be a little more flexible in the amount of hours they put in, the amount of emergency weekend crash research they do, things of this sort. It'll affect their conduct on the margins, to be sure. But I just don't see this overwhelming desire to be a partner.
Mm-hmm.
I hear just as many people saying, I'm going to work for a firm for 3 or 4 years and then leave, and either leave and start my own firm, or leave and go into the government, or leave and get together with a few people with a mindset like mine, and we'll have our own practice and run it the way we want to run our lives. They see themselves as having options. That, I think, by the way, is the biggest attraction of going to a large firm. That is, if you go work for a large firm, you have more options open. when you've been out. There's nothing more attractive to the rest of the legal profession than someone with large firm cachet.
Why?
Who has worked for 3 or 4 years and presumably knows something.
Oh, we've heard that all,
That's
all of
right.
these interviews. Why? Because,
I think it takes 2-3 years before you're worth anything. Every firm will tell you what we pay first-year associates is not justified by their output. But after a couple of years it is. But third-year associates don't get paid a lot more than first-year associates. The reality is all the large firms want to hire everybody else's third-year associates. They're still at a reasonable price. They're not close to partner yet, so they don't have those diplomatic niceties to deal with. But they already know what practicing as a lawyer is involved, and you don't have to hold their hand every 30 minutes. The hottest you will ever be as a lawyer is 2, 3, maybe 4 years out of law school. Everybody will want you. And they know it. They know that if they leave their firm, they can get snapped up at that level of experience by another firm in a heartbeat.
and why is that? Why? Because, obviously they had good grades to get into the best.
Mm-hmm.
They don't get as much trial experience, but they're
Almost
getting...
none.
Right, so they're getting a lot of...
They're doing support work. If they're in a litigation environment, let's say someone's joined a large litigation firm, the reality is the first 2-3 years they will be doing a lot of the support work. They'll be writing a lot of motions, responding to discovery, responding to motions, every now and then going to court and arguing a motion. But that's about it. I've talked to lots of lawyers over the years who have been in big firms for 3-4 years, and their actual court time experience has been maybe arguing 2 summary judgment motions and things of this sort. No trials. Or if they went to trial, they were the 3rd or 4th chair and basically sat there and watched. That's not meaningful trial work.
Okay, so let me ask you this then. Okay, you've got one person who went the public route and got lots and lots of trial experience, and you've got another person that went into the high-paying big corporate jobs.
Mm-hmm.
The big corporate person will be more do you think they have more opportunity, yet they won't? I guess it's sort of understanding why that is. Is it just a cultural phenomenon, or is it there's a reality behind it?
Well, part of the problem is that big firms want major, top-tier law school grads who have done well while they're there. The reason is, by and large, people that go to the best law schools and get the best grades are usually pretty good students. If they're pretty good students, most, but not all the time, it means they'll probably be pretty good new associates. So it's logical for them to want to hire those people.
Mm-hmm.
What kind of experience do they get those 3 years? In my view, their experience in a large commercial litigation law firm is not, when projected over 40 or 50 years of being a lawyer, practicing as a lawyer, is not as good as the kind of experience they would get actually trying cases on the criminal side. I'll give you an example. I did criminal work for about 7 years. Then I went back to doing civil litigation. I found that the biggest advantage by far I had when I went back to doing civil litigation, I was doing mainly med-mal work on the civil side, was people knew I had been a county prosecutor, they knew I had been a U.S. attorney, and they knew I tried a lot of cases and some big cases, and I had trial credibility. So that when I was litigating a case, I found that especially when it came to working out settlements, you had trial credibility. And conversely, the large firm people didn't. And I would always give them my speech. If I was handling a case that involved some lawyer about my age, working at one of the big commercial litigation firms in Chicago, I'd make it very clear to them that I didn't want to settle the case on the terms they were proposing. I wanted to try the case. That's where my strength was. Why would I settle a case and give up the advantage I had? And conversely, I want to try a case against you because you've either never tried a case or have tried one or two cases in your life, and I'm looking forward to the experience. What I learned quickly was that after all the posturing and preening was done, who the lawyer is on the other side and whether that lawyer has trial credibility has a lot to do with the kinds of settlements you work out. And I would be unabashed about it. I would tell them, if you want to avoid going to trial against me, make it worth my while. Otherwise, I would much rather try this lawsuit. Why not, right? And I found the flip side of that. Very often when lawyers fold on settlements, it's because the specter of actually trying it is looming on the horizon. And they know in their private moments that that's not their strong suit. And they give up something to avoid going to trial. Everybody knows it's true. Nobody talks about it. That's why I think the most important thing you can do as a litigator is to have trial credibility, and the only way you have that is to have tried cases. Big advantage.
That's really cool. All right, we're going to end with a really silly question that we've asked most people.
A silly question.
A silly question.
Okay.
Which is, what are some of your happy moments in law when you think about what's, and that's been different for everybody. I mean, what they've interpreted happy as.
I don't know if I'd use happy, but since I did trial work, I'd say exciting moments. You remember trials you've had or parts of trials where interesting things happen, either good things or bad things. I don't know if that corresponds to your notion of happy.
Yeah.
But I would say every trial lawyer has war stories where odd things have happened that just stick in your mind, and those little episodes are the interesting ones. I would say from a satisfaction point of view, it's when I was a criminal lawyer, of course I was mainly on the prosecution side, I did a little defense work, but not that much. I think the satisfaction comes from putting together a case. You know, cases don't just show up in court ready to try. And I found the most fun in trial work was actually getting evidence and finding it and putting it together into a coherent whole that convinces the jury that your side is right. I think that is much more of a creative process than non-lawyers think of it as being. I think non-trial lawyers think of trial lawyers as, well, you've got all the witnesses and you just parade them into court and they tell their story, and if you've got good witnesses, you win. And I don't think that's the way I see a trial lawyer. The analogy I usually draw is a trial lawyer is very much like the director of a play. You know, the director of a play is limited by the script. You can't change the script. If you're going to do a Faulkner play or, you know, Shakespearean play, you're stuck with the text. But how it gets presented on the stage, you can have a play come out so differently even though the same words are spoken. And that's what makes the directing job so interesting. You get to put your interpretation of set words so that they come out differently to the audience. I think the good trial lawyers ultimately are the ones that view what they should do in a courtroom the same way. That presenting evidence is a creative process, not in the sense that you get to write your own script. I mean, witnesses can only testify to what they say they saw and heard and did. But how that's presented to the jury, which witnesses you use, the order in which you do it, how you integrate visual aids to make the jury's learning visual, not just oral, that's, in my view, a creative process. And that's what makes trial lawyer fun. That's where I think the fun part of it is, not doing a particular direct or a particular cross. It's putting a case together and then presenting it to the jury in an interesting way so that your story, from your point of view, sticks to the ribs and is convincing. Again, I think that's a creative process. And I think that's the way good lawyers, good trial lawyers should think of trial lawyering.
Well, anything else before we end?
That's
That's
it,
it?
folks.
Thank you so much.